Hey guys, it's Jessie with Omaha Mom Talks, and I have some exciting news. I am partnering with Edwards Auto Group, a local car dealership with locations in Nebraska and Iowa, for a fun partnership called Mom versus Machine. Every couple of weeks, I'm going to be test driving a new family vehicle and giving it the full mom review. We're taking it out of the showroom and into the hands of me and my family of 4. We're going to be seeing if it can handle car seats, snacks, strollers, backpacks, how easy it is to clean, how much room do we have, and I'll be giving you my honest thoughts. If you have a car that you have been eyeing, let me know. If you have any must-have amenities when looking for a car, share them with me, and I'll be sure to give those a closer look. Follow along and see which car can actually keep up with our family chaos. All right, Tosha, thank you so much for being here today.
Absolutely.
Yeah. So before we get into all the legal stuff, let's just get to know you a little bit. Can you introduce yourself to our listeners?
Sure. So my name, as you said, Tosha Heavican, and I'm a partner attorney at Hightower Reff Law. So I actually live across the river in Iowa,
Okay.
but I come to Omaha almost every day and have been practicing with the firm for 8 years now.
Awesome.
So I went to the University of Nebraska for law school, and so I've been practicing I'm going on 15 years, which is kind of crazy to think about.
That happens fast, huh?
Yeah, time flies when you're having fun,
Yeah.
as they say. So I'm married, and I have 2 kids, and so when I'm not being a lawyer, I'm hanging out with my husband and doing kids sports and kids band. And
How old are your kids?
my son is 11 and my daughter is 7.
Okay.
Yeah.
And they're in a lot of activities, it sounds like.
Definitely. We do wrestling this time of year, wrestling, gymnastics. My son recently joined the jazz band too. And so, we have a lot of fun.
Okay, awesome. And have you always been in this particular type of law, or have you practiced other types of law as well?
Sure. So when I first became a practicing attorney, I actually started out doing personal injury and workers' compensation cases, which is mostly representing plaintiffs or individuals when they're suing for damages. I did that for about a year and decided I kind of wanted to just take my practice in a different direction. And so I started working for an attorney who did a lot of the types of work that I do now. And that really is what was the jumping off point for me.
Okay. And tell us a little bit about the type of families and clients you typically serve currently.
Sure. So what's really cool about what I do, and I have said this for years, estate planning really is for everyone. Mm-hmm. And there's so many different levels of planning that you can do. And so it really can be tailored to what that person needs. And so I have helped single individuals as young as 19 as soon as they can sign documents, and we're making sure that we have things in place for when they go off to college and mom and dad aren't maybe there.
Yeah.
All the way up to I have helped aging clients, people who maybe know that their time is coming, and so we need to make sure that we have things in place so that the transition is smooth legally for both taking care of them, from a healthcare perspective, and then also transferring of their assets.
Yeah. Okay. So really there is a big range of folks
Absolutely.
that you serve, and certainly that can benefit from estate planning.
Definitely.
So let's dig into some of these legal terms and some guidance and advice for the moms that are listening. I also, just for the listeners, am not super savvy on these terms, but I have had both of my parents have died, and so we've gone through some of these things, and like literally was like the blind leading the blind, and things that I thought I knew were wrong. And
Sure.
so I think that this conversation is important for people, like you said, at any life stage, whether you have aging parents or maybe you have your own little family that you're trying to protect and plan for. So let's just get into it. First, if you could just describe to us in simple terms,
Sure.
What is estate planning?
Sure. So I think that the easiest way to think about what estate planning is to think about what happens in sort of these two life events that potentially could happen. So the first event that we typically talk about is a situation where something would happen to you and you are still alive, you're still with us, but for some reason you can't handle your own affairs or you can't make your own decisions, whether that's because you're having a healthcare episode or maybe you physically can't go places. And so to be able to, for example, go to the bank or, go somewhere to pay a bill, things like that, right? And so when we have a situation where a person is what we call incapacitated, right? So they can't handle their own decisions, they can't handle their own affairs, then we want to have documents in place through estate planning that allow somebody else to step in for them. And that planning, when we do it ahead of time, it avoids having to go to court. It avoids having to involve a judge and the time and the expense of having an attorney to go to court, things like that, by doing these simple documents in advance. The other part of estate planning that I think sometimes people probably think more so of is a situation where something would happen to you and you pass away.
Right.
And so when you're no longer with us, then we're asking the question, okay, what are the assets? How are they titled? One of the biggest things that I talk to families about of all different shapes and sizes and all different types of estate planning clients, it's so much about planning has to do with how assets are titled.
Okay.
Whether the bank account has $100 in it or $1 million in it, whose name is on the account and how the name is on the account is the number one question I'm going to ask. Because when you look at a time period where someone has passed away, then we're looking at how do we transfer the assets if they had any, how do we pay off debts if they had any, what are their wishes for funeral and, last rites, last wishes, things like that. So those two life events is what we try to talk about with our clients and put together a plan, an estate plan that would sort of spring into action in those situations.
So I'm somebody who likes to know, like, if I'm doing this thing, what are either like the goals or what are my brain always goes to like, what's the return on my investment here? And so if I am, encouraging folks, like, this is why you should do estate planning. I hear you saying like, it's protecting yourself and your assets, but also just that, avoiding like the chaos that can come.
Sure.
Right. As somebody who is a griever and has lost my parents and has seen lots of other people lose family members, you are just stricken with this intense emotional response, which doesn't allow for you to access that logic and reasoning in your brain. So
Sure.
if you have this plan, oh my gosh, how much simpler. Right.
Well, I think to your point, especially in the first scenario, when we're talking about a situation where a loved one, say a parent, needs help, right? So a very common example that I see is a family member, a parent or a grandparent develops dementia, right? And sometimes clients are calling and they're saying, okay, the doctor has said that grandpa can no longer make his own decisions, so we need to get a power of attorney. And at that point, it's too late because the person who needs the power of attorney has to have capacity at the time that they sign. If we do that in advance, then here's the difference, right? So if, in my example, if grandpa had done planning in advance and he has a power of attorney, he develops dementia, the doctor says grandpa can't make decisions, then whoever grandpa chose, if it's a child or a spouse or a close friend, to be his person, then that letter from the doctor makes it so that now that person can make decisions. Okay? If we do no planning and we have the same scenario where grandpa gets the letter that says he can't make decisions anymore and now we need to put him in a care home, if grandpa can't make those decisions for himself, he can't sign a contract to do that, and we don't have a power of attorney, then our only legal option is to go to court and have a judge declare in a court order that grandpa is incompetent, And then that judge gives the person who's applying the authority to make decisions for grandpa. So in that scenario, one, you're going to court, which takes longer and is more expensive. And two, grandpa's not choosing who's filing in court. It may be a child who potentially could do nefarious things. Maybe not, right? Not every person in every case is bad, but that's the control as the principal, as the person who needs the help. That's the control they lose by not doing planning.
Yeah. So a lot of our listeners are families with young children, and sometimes I hear from folks in regards to both financial planning and estate planning is they feel like maybe it doesn't apply to them or isn't as important because they don't feel wealthy or yet established. What would you say to those folks and why it's still important even if you're not feeling like you're wealthy or well established?
Absolutely. So kind of back to what I said earlier, estate planning is for everyone, okay? And so much of what we do about estate planning has nothing to do with how many dollars you have in your account. Specifically with families who have young children, very similar to my own situation and thinking about what would I want to have happen if not only myself was gone, but also my children's other parent, right? Which sometimes can be really hard to think about.
Absolutely.
Right? Because, it's an unthinkable situation for parents, right? And so when we're talking about that situation, one of the things that is really important to talk about is, okay, if something happens to both parents, two questions. One is, who would you want your children to live with and be with? That person likely would be the guardian, not always, but typically. And once we know that person, we can, within a will, the Nebraska and Iowa statutes allow us to put in a will, if I die, this is who I choose to be the guardian. And that person is going to be number one on the list. So they get what we call priority of appointment. So they get to be first in line.
Okay.
The second part of the question is, who do you want to be in charge of money for your children? So we think about not only potentially assets that the parents have that would then go to the children if both the parents are gone, but also typically you're going to have Social Security dependent benefits that get paid every month until the child turns 18, and that's paid typically to a guardian or conservator.
Okay.
So sometimes that person is the same person, right? Sometimes families feel, my sister is excellent with my children. She would do so great and would raise my children the way I would want them to be raised. And so I would choose her as the guardian. But she's not the best money manager, right? Or she won't be able to say no when the kids want, the latest and greatest, right?
Yeah.
And so thinking about who would be a good person to help give any sort of funds that you have some longevity, right? Some planning. So we talk through that. The other thing to think about is when you have children who are inheriting money, there are specific rules about that. And so by doing planning in advance, we can set up trusts that would exist at that time to help manage the money.
Okay. So let me back up for just a second.
Sure.
Because I know this conversation about like guardianship and what happens to your children should the unthinkable happen is something that we all fear and I want to spend some more time on. But for a parent who has minor children and passes away, say both parents or it's a single parent, and they have no plan for guardianship, then what happens?
It's typically the first person to file in court. So what that situation looks like, and I've had these cases on many occasions, mom and or dad passes away, and now we have, 1, 2, 3 plus children in a situation where they don't have any caretakers. So the legal system for guardianship allows us to do a couple of things. First, we can file what's called a temporary guardianship, and that can get issued even without a court hearing. If there's an emergency or something like that, we can send information to the judge and say, here's the situation, Judge, we need you to appoint somebody. And this is the person that we're picking, whether it's an aunt, an uncle, a sibling, sometimes an older sibling. But it's really whoever sort of steps up. It's not there isn't a list that we go down.
Can I just pause for just a second? Because I'm thinking, if I was the aunt, I wouldn't know where to go or what the timeline is. So is that something that should be done urgently? And do we, in our city, do we just go down to the courthouse and file? Like, what does that kind of look like?
Sure. So, of course, my initial response is going to be call a lawyer and sort of talk to them about your case and see what needs to happen. But a lot of times what happens is, in the early stages, families are grieving, as you've talked about, right? And so a lot of times what will happen is something will come up where either a school, so let's say a child needs to be registered for school, or let's say they need some sort of medical care, a doctor visit or something like that. And a lot of these places and institutions are going to say, well, we need your letters of guardianship. We need your paperwork to show that you are in charge of this child. And then when you don't have that, then it's like, oh no, what do we do?
Yeah.
Right? And so sometimes it takes a minute.
Yeah.
And so, but once we sort of figure out, okay, this is the process we need to go through and this is what needs to happen, then the case, so for Nebraska specifically, guardianships are filed in county court.
Okay.
And so you would file in the county that the children are located in or the county that you live in. Typically, if you're going to be the guardian, you would want to file in your own county just because you have to go to court and it's probably closer. And then if we do that emergency one, a lot of times we can get some paperwork within a couple of days, depending on the situation. But then outside of that, the court sets it for a hearing.
Okay.
And so you go to court and you have to talk to the judge. And typically you're going to have to present some sort of evidence as to why you should be the guardian. And for cases involving minor children, and your listeners probably have heard this phrase a million times, but it's whatever is in the best interest of the child. So if in a case we had competing petitions, let's say we had, the person died and they had a sister who filed and they had a mother who filed, right? And they're fighting and they're both saying, I'm the best choice, right? Without some sort of settlement or agreement, there's a trial.
Okay.
And the judge looks at the evidence and makes a decision about who should be the person. And it can take a long time, as you can imagine. And so typically during that time, a temporary guardian is appointed. And a lot of times in guardianship cases with minor children, well, even and with adults too, the court will appoint what's called a guardian ad litem. And that person is an attorney typically, and they look out for the sole best interest of the child as well. Mm-hmm. So it's almost like the child has their own attorney also.
Right. Yeah. So getting into this hard emotional discussion about choosing guardianship, right? Because I think that is something I know my brain naturally wants to avoid, but also is like, but that's like the responsible thing to do.
Sure.
How do you kind of encourage parents to start making that decision, and what factors or questions can they ask themselves when selecting who would I want to take care and raise my children should the unthinkable happen that me or my partner die?
Sure. So a lot of times the conversation centers around sort of what we were just talking about, which is if you don't make a decision and this becomes a problem or becomes something that we are confronted with, then somebody else will have to make a decision. And typically it's going to be somebody that doesn't know you. The judge maybe has never met you, knows nothing about you, your spouse, your children. And of course they're going to do the best that they can.
Right.
But by sort of taking the bull by the horns and saying, okay, this hard thing we have to really work through and think about and talk about our kids are going to be better off than if we sort of try to avoid it. Right. And then the other thing that I really try to work through with clients is thinking about, okay, typically we look at planning for like the next 5 to 7 years. Okay. So maybe right now, for example, for me, maybe my parents or my husband's parents would be a good choice for the next 5 to 7 years. But let's say 7 years from now, my kids will still be minors. And maybe at that point, my parents and my in-laws may not be the right choice, right? They may be getting older. They're in a different life stage. And so then we look at making amendments. So sometimes we have to kind of pull in our view a little bit. It shouldn't necessarily be a conversation of this is the person forever.
Yeah.
Right?
Yeah. But like that 5 to 7 range.
Yeah, exactly. Because, most of the documents that you're going to be thinking about and doing and decisions you're going to be making, you can change your mind. It's not, I like to say, it's not written in stone, it's written in sand.
Okay.
Right? And so we think about for the next 5 to 7 years, what makes the most sense? Who could physically be able to take on, in my case, 2 additional children, right? Other things to think about. If you are choosing a guardian and you're both gone, would your children have to move, right? Are you choosing somebody that lives in a different state?
Yeah.
Which may or may not be okay, right? And that's the other thing is that there's no wrong answers, right? It's just really trying to make sure that the decisions that you're making are ones that you are comfortable with. And the next thing I would say is I would highly encourage having a conversation with that person, right? So if you choose that person saying, hey, is this something that you're willing to do? And if it were to happen, right? Because there's no requirement. If I name somebody as a guardian, they could say, I'm out.
Yeah.
Right. And so to that point, a lot of times in my documents, we will have somebody in the number 1 spot, and then we will also name a number 2.
Okay, I like that.
Right. So let's say I did have, my parents, and then maybe it's 12 years from now and I didn't make an update, and then something happens, right?
Yeah.
We can say at that point in time, my parents could say, we're just not, we will be supportive and we will love the kids and we will visit them all the time, but we think maybe the person in position number 2 is better suited, and they agree or whatever, right?
Yeah.
So I try to make the planning that we do as malleable, I guess is a word, as you can. So it's, it's still workable if life changes.
Yeah, absolutely. So when I think of like selecting a guardian for my kids, some of the things you said, like location, certainly their age, anything else that I'm trying to even think if there's anything else that I know every family has their own, right? Like as parents, we're making decisions all the time about religion, education, like all of those factors, and deciding like how much of that is important to you at that time and how much of it is like, well, this person fits enough of the things that are important to us.
Exactly. You hit it right on the nose. I mean, it really is a question of, who would raise your kids the most like you, right? And it's a tough thing to think about, but you kind of have to, as you said, think about what are your priorities, right? You really maybe are a family that really believes in going to church and having worship and things like that. Then you would navigate maybe towards a family that does that versus if you're a family that and not that these things are mutually exclusive, right? I mean, it's all on a spectrum, but or if you're looking for somebody who maybe is more active and into athletics and things like that, right? Yeah. So I think really having a conversation with whoever you choose is the key, right? And thinking about could they take this on, and understanding too, we work a lot in probabilities, right? The likelihood that both parents would die either at the same time or in close proximity to each other where the one or more children are still minors is not impossible.
Right.
But it's also a lower risk than
lower
somebody,
probability.
right, than somebody who's maybe in, an older age or something like that. And so, the likelihood of it is fairly low in most cases, but still understanding that if we take a minute to just think about what would make sense in that scenario, it's so much better than trying to make that decision later on.
I also was thinking about, and I'm wondering if this makes a difference or if you have a guidance on it. Say I'm figuring out guardianship for my children if the unthinkable happens, and I'm thinking I want my sister and her husband. This is hypothetical because my sister's not married, but I would choose my sister. So I'm like, I want my sister and her husband. But really, I really just want my sister, and I'm thinking, like, what if they got divorced, or like, what if he died, or what if she died, and then is he left with them? Like, so do you have any guidance of like, should it be a couple? Should it be a single person? Does the wording matter? Am I overthinking it?
You're not overthinking it, and words matter,
Okay.
for sure. So when clients because part of my process is I have an estate planning workbook that I give to clients to work through as part of our initial process. Because then that helps me when we sit down to talk about the planning, so I can tailor the conversation to the things that are actually important to them.
Mm-hmm.
And so when they write down Brian and Susie, and I say, well, who's Brian? Well, Brian's my brother. Okay, well, who's Susie? Susie is his wife. Okay. Do you want me to list both of them? Do you want me to put and or? Because some people, maybe Brian is their only sibling.
Yeah.
Right? And they would be okay with Susie being it if Brian passed away or whatever. And in other cases, they say, no, we don't even really like Susie. We just didn't want her to feel left out or whatever. And so, to your point, words matter. And so we really try to be cognizant of who we're listing and how we're listing them.
Okay.
Because a lot of times people will list, kind of how I mentioned before, I would list my mom and my dad. Well, if it was just my dad, I would still be okay with that, right?
Yeah.
But it may be a situation where one person taking on 2 kids versus 2, that's different too.
Mm-hmm.
So,
yeah.
But definitely in planning, we always have very specific conversations about in-laws, I guess, for lack of a better way to say it, right? Are we including them? If you have a situation where one of your children passes away, in some cases, families are very close and they want to still have that in-law person involved. Other people don't, right?
Mm-hmm.
And so, and again, it's not a right or wrong thing. It's just whatever is important to that person.
Yeah, and thinking it through and maybe including that in your plan. And I like your guidance of talking to that person directly, right? Having them be a part of that conversation. No one wants to be a surprise, like, now I'm a guardian for these couple of kids and I feel obligated. Because we actually had a situation with a family member with special needs that we asked another family member, I wasn't a part of it, but was asked, like, would you be comfortable one day being guardian? And this couple said no. And there was some feelings there and emotions. But to me, I'm like, thank you for being honest. Like, you didn't feel like you could give that, maybe the attention, or you didn't have the capability, or whatever the reasons are, but you knew your limitations. And thank you for not just saying yes.
Right.
Because it can feel like an obligation, I'm sure, to some people. And so I love having that conversation and making sure they're agreeable to it.
I think, with guardianship for kids and also healthcare power of attorney is extremely important, right? Because, in that document, not only are you asking people to make healthcare decisions for you on a day-to-day basis, let's say you have dementia and so you can't decide, who your doctors are, what your medications are, but also when we're talking about end-of-life care decisions, right? And so just sort of springing that on someone, and then, you're in a traumatic accident or something and they're saying, okay, it's time to decide, and to not have some sort of advanced warning, I think is a difficult position to be put in for anyone.
Mm-hmm. Absolutely. So let's chat a little bit about power of attorney, because this is something that was confusing to me when my mom died about a year and a half ago. So she had declared my brother power of attorney, or the agent, whatever. And
Sure.
What I learned, and maybe this is common to everybody and not me, but that power of attorney ends when said person dies.
Yes.
So I thought, like, bro, you're the power of attorney. Call her bank. Call her this. Like, I can't call all of those places. But we learned that. So talk to us about what is power of attorney, and then maybe I'll have more questions.
Sure.
As we go.
Sure. So you're exactly right. When you have power of attorney, typically two kinds, one that deals with financial decisions and one that deals with healthcare decisions.
Okay.
And you can only have power of attorney over somebody who is alive. So once a person dies, that power of attorney goes away.
Okay.
And so then if somebody is taking actions as a power of attorney after that person has died, then potentially that's a no-no, right? Mm-hmm. And so because once the power of attorney is no longer effective, then we're looking at what are the testamentary documents. So that's going to be things like a will or a trust or titling on accounts, things like that. So power of attorney is making decisions while a person is alive. Mm-hmm. It's like a surrogate, or they're standing in the place of the person to make choices.
And as you said earlier, just to add, that is something that the person decides for themselves while they still have the capacity to do that.
Right, exactly. I have a power of attorney, and I have named my husband, and then for healthcare, and if he can't do it for some reason, let's say we're in a common car accident, right, or something like that, then the second person in line is my mom. She would make decisions for me unless and until I improved to a point where I am no longer incapacitated, or until I would pass away.
Okay. And so let's talk a little bit about living wills, and I guess or maybe wills versus trust. I think sometimes there's some confusion there.
Sure. So to your first question, and I get this all the time, right? This is such a common question. There's a last will and testament, which is a document that you would fill out or sign that has what happens to your assets. It also has all of the stuff in it about guardianship of my kids, who would handle my affairs after I'm deceased. A living will, which is like almost sounds exactly the same, but a living will is actually a document under it's a different statute. And what the living will allows you to do is it allows you to sign something that tells your physician to terminate treatment if certain requirements are met. It's under the Rights to Terminally Ill Act. Okay. And so the way that I kind of like to think about it is the living will and the power of attorney for healthcare are somewhat in the same camp. The power of attorney for healthcare says, I, Tosha, appoint my husband, Cole, to make healthcare decisions for me and to terminate treatment under certain situations. Okay? The living will document says, I, Tosha, tell my doctor that if certain things have happened, I am in a persistent vegetative state, I want you to terminate treatment. So it takes the power away from your agent, right? Mm-hmm. And it tells the doctor, right? So then the doctor has this extra power to be able to make those decisions. In my practice, for living wills, I do them they're not as common, just from my perspective, because most of my clients want their families making that decision. But I have done them, especially in situations where I've had younger clients who have health issues. They have concerns that maybe their family wouldn't terminate treatment, and they don't want that. Mm-hmm. And so making sure that there is a decision maker that would emotionally be able to make that decision.
Yeah. That makes sense.
So those two documents, the living will and the healthcare power of attorney, in my view, kind of are in the same camp. So then you have the last will and testament and the trust that you mentioned. So these documents deal with assets and are able to transfer assets after you are deceased. Okay. So a will, this is another sort of common question that I get. So a will controls what we call probate assets. Okay. A probate asset is going to be an asset that is in one person's name only with no beneficiaries. So if I have a house that is just in my name and I pass away, that is considered a probate asset. And so then we would go to the will, and the will would say all of Tasha's assets go to her husband Cole. So then that house would transfer to Cole through a probate process. If that house says that it is owned by Tasha and her sister Michaela, but Tasha's will says everything goes to Cole, my will does not control that house because it's not a probate asset. And that's why titling is so important. Mm-hmm. So where I see this all of the time, so many cases, is let's say we have an elderly parent. Let's say they have 2 kids, son and a daughter. And the elderly parent says, I'm getting up in age. I don't want to have to deal with, the bills and the day-to-day stuff, right? So I'm going to add my daughter to my bank account so that she can handle my affairs. And let's say for the whole time the daughter does everything perfect. She does nothing wrong. She's not taking money. She's just paying bills the way she's supposed to. And then the parent dies. Well, daughter is the joint owner on that account. Let's say there's $100,000 in it, okay? The law says that the daughter gets the $100,000, even if the will says I want everything split between my 2 kids. Because the account was a joint account, the will does not control it. And the bank is going to pay over that whole account to the daughter.
Okay.
So we have to pay attention in planning on how assets are titled. The thing with trusts is I like to think of a trust as like a bucket. Okay. So instead of having assets like a bank account in my name, and then when I die, it is probated through my will, I can put my bank account in my trust bucket. So then when I die, there's nothing to probate because the trust owns it. I don't.
Okay.
Okay. And one of the main reasons that we do that is probate avoidance.
You're right.
Right? So when we have a probate estate where it's controlled by the will, then what happens is the personal representative, which is the person that is chosen under the will to administer the estate.
Is that the same as an executor?
Yes.
Okay.
Yep. You'll have administrator, executor, personal representative, and for the most part, they're kind of the same job. There's some nuances, but for our purposes today, they pretty much are the same.
Okay.
And so that person, whoever's named in the will, takes the will to the courthouse and says, okay, mom has passed away and now we need to probate her estate. The estate gets opened in the court, and then the person that was chosen, the personal representative, collects assets. So for example, they go and get the money from the bank account. If there's a house, maybe they sell it, or if there's a car, they're going to sell it. If there's life insurance, they're going to collect the money, right? So we're going to get everything into the estate. We're going to pay all the debts, and then we're going to distribute the money based on what the will says. And then we're going to close the estate. So that's all done within the court system. And a lot of times for estates that, nobody's fighting or anything like that, you don't have to have hearings necessarily. It's just a lot of paperwork.
Yeah.
And there's deadlines you have to meet with the court in terms of filing an inventory and paying the inheritance tax and things like that. So the difference between that and the trust is that if you, instead of when you pass away having assets in your own name, if they're in your trust, then when you pass away, there's nothing to probate. And the trust is then administered by what's called a trustee.
Okay.
And so let's say that I pass away and I chose you as my trustee. Then when I pass away, you say, okay, the trust says I'm supposed to pay Tasha's debts. So you do that. You collect the assets the same as the personal representative, but you didn't have to file anything in court. And then you pay the debts, you distribute the money, and you're done.
Okay.
So a lot of times the trust process can be quicker. It depends, right? Which is such a lawyer answer. But in Nebraska, we are special. That's the word I'll use.
Okay.
Because Nebraska is one of only a few states that still has an inheritance tax. So at the state level, depending on how much your estate is worth and who is receiving your estate, there is a tax that gets paid to the county, either that the deceased person lived in, or if they owned real estate in multiple counties, then they get some of the money too. And so that that process is a court proceeding, even if you have a trust.
Okay.
But you don't have to open an estate to do it. So it gets a little bit, there's a lot of rules in probate court, which is why I like it, because I'm a rule person.
Okay.
I like instructions, and I'm going to follow them, and, that sort of thing. Yeah. But I think the couple main differences, if we were to sort of circle back to your question, between a will and a trust. Typically, we're going to use the trust if probate avoidance is a goal. Some clients say, I don't care, and that's fine. That's totally fine, right? So that's one option. The other couple that I see, one is if you have minor children and you're thinking that you want to hold on to the money for longer than when they turn 19.
Okay.
Right? So, and part of that conversation with clients is saying, okay, let's say that you died and your children, let's say they're adults, but they're 20 and you pass away, right? How much would your estate be worth?
Yeah.
If you pass away, and let's say we sell your house, so whatever equity you have in your house, your bank accounts, your 401k, if you have other investment accounts, if you have life insurance, let's say, what does that number look like, right? Okay, do you want that entire amount to go to your 20-year-old?
Right.
And if the answer is no, then we look at, okay, maybe we give them 50% at 25, or we give them a third at 25, and then we give them some a little bit later, and we can put provisions in the trust to pay for school and to help buy a car and, different things like that. And that's where the conversation gets more into what is important to the client, right? What are their goals with their estate if they were to pass away at these stages in life?
Yeah. I think one of my questions was, when is a trust helpful for kids? And those are just really clear points to me of like how to help them prepare for life events and things like that, where I'm still helping them beyond.
Sure. Well, and there's different types of trust too. So you can have a trust that exists now, so where we're completely avoiding the probate process. Or I use a lot of times with families who have minor kids, but maybe they don't feel like, the likelihood of both of us passing is pretty low. We don't really feel like we have enough assets right now where a trust makes a ton of sense to set it up now. So what we can do is within the will, we can say, okay, we're going to do what's called a testamentary trust.
Okay.
And so what that means is we say, okay, if Tosha passes away, all of her stuff is going to go to her husband, Cole. Fine. Great. But in a situation, an unlikely situation where Tosha and Cole both would pass away at the same time, then we say, okay, my two kids would potentially have assets then at that time, and they're too young to manage them. Okay. And so the will says, if that situation happens, then we are instructing the personal representative to set up a trust.
Okay.
So so we would still have to go through probate. So it's not a probate avoidance tool, but it does still give us some comfort and some feelings that in a situation, an unlikely situation that does happen, there would be safeguards in place to put this money into a trust so that, my kids are not getting it right away when they turn 19.
Yeah.
Right?
Super young.
Right.
Lord. So we know life is unpredictable, and like we said, like some of these things aren't probable, but they are possible. What are some key things that parents with minor children should have documented to protect their children if the unthinkable were to happen?
Sure. So I think number one is going to be, choosing that guardian situation. Who's going to take care of the kids and who's going to manage their finances until they are of an age that they can do it themselves. That's going to be number one.
Yeah, and I love just the distinction you made about it can be who's going to physically handle the kids and then the finances. Those can be two separate people. I think
Absolutely.
My brain thinks it has to be the same, so that's great for...
And in some cases it makes sense maybe to have two people, right? Not always, but, sometimes. So, that's just part of the the planning process is thinking about what makes the most sense, and then maybe just having a secondary. I always call it, I'm a belt and suspenders kind of person, right? So we want to have one first position, one in second, just in case.
Yeah.
I think, generally speaking, in terms of estate planning, what's helpful for clients that I work with is if you have a place that you have put, like, this is the financial planner that we use.
Yes.
This is where we do our banking, right? Not that you have to tell all your business to your kids or your siblings or whoever your person is, but just, a place that says if something were to happen, you need to call this person at this place, or, and these are where my accounts, this is where I bank.
Yes.
These are the life insurance policies that I have.
Yes.
I have, here's a crazy kind of tidbit for you. In the last 3 months, maybe even 2 months, I have had 3 different clients call me, and we're working on cases for them now where we didn't know about an asset. And so then, we've done all the paperwork. We've closed the estate. We've done the grieving. We've moved on. And then we get a notification, a letter that says, hey, we have this account that has money in it, which is a great problem to have, right? Right? I wish someone would find an account with my name on it.
Same.
But, we find these accounts, and then we have to sort of, do the paperwork to get the funds. And it's simply just a lack of knowledge, right? Of knowing where they had their things.
I'm laughing inside because we went through this with my dad. He passed in 2020, and we grew up here in Nebraska. He banked in our small town, but also another small town sometimes. Then he moved to Texas for his last remaining years. And so he had told us all that he had everything written down somewhere. And I don't know if he did or we just didn't find it. But we were like calling all of these places, and you're grieving, right? And you're sad. And not to mention, like, I'm a mom, I work, I have all these other things going on. And, you call, and each person is so kind, and they say, I'm sorry for your loss. And either like your name isn't on this account, I can't tell you anything.
Absolutely.
Or we have like nothing to offer you, dead end, right? And so it's like, oh my, so then we made sure that my mom had everything as in order as possible. It still wasn't a perfect plan. We still had a lot of phone calls, scrambling, whatnot, but it definitely was much more manageable. And to me, like, that's a gift that I want to give my children.
Absolutely.
Hopefully my children are very old by the time that, I pass away. But to me, that's a gift that I can give them by just taking care of all of that, having it as simple as possible. Call this person, step 1, step 2, step 3, and close the book and live your lives.
Absolutely. Absolutely. It's definitely makes it a much smoother transition, especially for if you think about the person that you choose to administer your estate, right? A lot of times when I work with parents who, their kids are young adults now, right? So we don't necessarily have the questions about, okay, if we pass away and our kids are minors or our kids are 22, right? The kids are in their 30s and 40s, and it's like, okay, how can we make this process easy for them?
Yes.
What are things that we can do? And the planning makes it so much simpler. I talk with clients about, the idea of the powers of attorney, the wills and trusts. We do touch on, if you're in a position to prepay for burial and funeral services, as it stands, I think, things only get more expensive, right? As time goes on. And so if you're in a place to prepay some of those services, it just makes it so much easier for your kids and your loved ones because they know it's what you wanted because it's already there.
Yes. I'm laughing again, and I have a bit of a morbid personality at this point in my life, but my mom had told us for years that she had prepaid her burial. Call Roper and Sons, they have it, and then when we did, after she passed unexpectedly, she had made one payment. And there was a lot left on this.
She had the Maserati of funerals.
Yes. And I love that she, had the idea and tried to execute it. She doesn't get very far with it. And they were so sweet. They're like, we can refund you like her one payment.
Sure.
Because we were going to go a different direction. But it was like, the thought was there, like,
Sure.
and man, that would have been nice. Like, we wouldn't have had to do all this extra planning. But yes, so I love the idea of prepaying for your
Yes.
funeral arrangements to make it easier on your loved ones. I want to talk a little bit about just like action steps, because I know like this can feel overwhelming for folks
Sure.
when you're dealing with all the other busy chaos of life. But what can those that are interested in estate planning, what is a first step? Like, are we collecting documents? Are we getting information? Like, what does maybe a first step look like?
Sure. Honestly, I think that the first step, whether you're a single person, and in that case, you're sort of having a conversation with yourself, or if you are in some sort of a relationship where there's a counterpart to you, it's really sitting down and thinking about what is important to me and what are my wishes. I like to do a 30,000 foot view of, what are the assets, right? Because again, for me, there are some things that we talk about in terms of value when we're talking about taxes and things like that. But I think the initial step is, what is most important to me and what is my legacy if I were to pass? I have quite a few clients that do some charitable giving also, which there are ways that can help with your taxable estate. And I try to work with financial planners as much as I can with my clients to make sure that we're all on the same page and we're getting the best tax treatment for your money also, right? But thinking about, okay, I have a spouse and I have kids and maybe I have these certain causes that are important to me, and so what is top of mind for me of if something were to happen to me tomorrow, right? What do we need to have happen? Because then that helps me as the attorney guide you and, okay, these are the documents that I think that we should draft and that you should execute.
Yeah. What's most important.
Right. And I think sometimes estate planning feels daunting because people think, okay, well, I got to get a bank statement and I got to get my 401k account. And, I don't need those account numbers.
Okay.
That is not, I don't, we're going to talk about what you have in your estate in terms of funds and, assets. Do you have a house that you go to in Arizona, right? Because that helps, because then we're looking at multiple states, things like that.
Yeah.
But I don't have to know, the exact penny of what you have in your 401k, at that exact moment.
Especially to get us started.
Right.
Yeah. Okay, my last question, I'm just curious, for those that are like, can I DIY this?
Sure.
What is your advice to those folks?
Please don't.
Okay.
Right, which is probably the expected answer. But I have had, real life cases where people have done their own plans, and within the probate system, if certain rules aren't followed, then it just makes the process harder. We have to spend more time. We have to have a hearing with the judge to approve things that don't follow the statutes. The other thing that I will say too is, because I've went through some of those modules just to see how it works and what happens. If you have any sort of specialized thing that you need in your estate plan, it's really hard for those templated things to get to the root of what you need. A great example I can give you is I do a fair amount of special needs planning. So if you have somebody in your life who has special needs, we have to make sure certain things are in there so that their benefits aren't messed with, and and those types of things. And so, and my second thing that I would say to that is if, estate planning feels scary, or maybe it feels like it's not something I'm going to be able to afford, or, that sort of thing. My office, we have developed this program called Will Express.
Okay.
And it's for basic planning. Okay. And we have different levels. We do it once a quarter, so 4 times a year. We actually have a specific tab on our website so people can go and check it out. You don't pay for a consultation. You get we set aside a whole day where all we're doing is wills and powers of attorney. And we really try to make estate planning accessible, especially those basic documents for people. And so if nothing else, that's a good place to start, to say okay, what is this estate planning about? And what can I
What'd you say you call it again?
Will Express.
Will Express. So we can find that on, what's your guys' website? I'll put it in the show notes.
Oh, sure. hrlawomaha.com.
Perfect.
So at the top, there should be a tab that says Will Express, and there's tons of information on there, and we have blogs and stuff on there too. But it's a great place to do basic planning.
I love that.
To kind of get yourself started, and so then you can feel. I always tell people after they're done signing their wills, I'm like, do you feel like an adult now?
It is the maximum level of adulting. I agree. Oh my gosh. Well, Tosha, thank you just so much. I know that for some people, estate planning is something that's either too hard to think about or just feels like maybe something that'll get to later. But I think that the insight and conversation today hopefully will allow people to, again, hear that estate planning is for everyone, no matter where you are at in your life or on your wealth or financial journey.
Sure.
And that, to me, it really is about extending love to those that you care about. It's the best way to love on them is to have this plan in place.
Absolutely. I say that too, especially that, just being able to give them that peace of mind so that they can love you and be with you, and they're not meeting with someone like me instead of being, where they need to be. And so I truly appreciate this opportunity. I try to do, as much education as I can, because I think sometimes estate planning feels so daunting, and it really can be a good tool for families. And so I'm happy to be here, and I really appreciate it.
Yeah, thank you so much. So we will put the website in the show notes, and then you guys are on Instagram, I think TikTok.
Oh yeah,
Facebook,
all the things.
All the social platforms.
All the things,
where
yeah.
folks can learn more and reach out if they want to work more with you or any of the other lawyers there. So thank you again so much for taking the time to join us.
Sure.
For those that are listening, if this episode has been helpful, please be sure to like and subscribe Omaha Mom Talks. It helps more listeners find us. And please take good care of yourself, and we will check in with you next time. Bye.